about to take the court through the reasoning of the judgment. The judgment is long, 56 pages of closely written text. I obviously don't have time to take you through all the detail, but what I hope to do in my submissions is give you a fair sense of the big picture by focusing on what seems to us to be the critical parts of the court's reasoning. I'd ask the court that we begin at paragraph 78 of the judgment, which is at the bottom of page 83 of the core bundle. It's tab 5, page 83. We see from this paragraph that the court makes reference to our witnesses at trial. What we gather from this paragraph is that the court viewed our witnesses as being essentially honest and helpful. The court notes in the penultimate sentence that none of our witnesses were in post at the time and so were doing their best to reason backwards. Then we skip on to paragraph 88, please. 87, the court starts to deal with issues around safer gambling. At 88, the court notes that we regard ourselves as a market leader when it comes to safer gambling. It notes that our approach to safer gambling had evolved over time, but that our position was that we'd remain compliant without. The important point I want to make at this juncture is that, as I'm sure my learned friend would accept, there's no finding in this judgment that we fell short in any respect in terms of compliance with our safer gambling obligations. The court does make, as we shall see, some passing comments on how our safer gambling mechanisms worked, but it doesn't find that those mechanisms were insufficient, such that we failed to discharge our Gambling Act obligations. 89 to 90 addresses our evidence as to how we approached our risk analysis under the safer gambling regime. Paragraph 91 notes that at the time we were trying to assess risk by reference to the transactional data we held, because that's all the data we had access to. We didn't at that point in time have access to wider data about customers' finances, health, employment or home life, or their self-exclusion from other platforms. Things have moved on since in terms of the approach to safer gambling, but that's how matters stood at the time. The court says in paragraph 91 that she says that all of these additional data points that weren't before us would be relevant to the management of risk, but nowhere in the judgment does the court say that this was information that we ought to have or even could have reasonably obtained at the time. Indeed, we see from the next paragraph, 92, that the court proceeded on the basis that the net effect of the fact that we only had limited data points available to us meant we were operating within an environment where there was a high risk of false negatives. There was a high risk that some proportion of our users would be problem gamblers. Note the penultimate sentence. There was a lot of information which we did not or could not factor in. In paragraph 93, the court appears to be acknowledging that addressing the problem gambler is not straightforward. For
going back to 92, is that a finding or is that just a recitation of Mr. Watkins' evidence?
I think that that's the court's. This is the court's finding about as to what is shown by the evidence that it's heard. As we read it. I mean, it's a bit unclear, I accept, but that's how we've read it. Paragraph 93. Court certainly doesn't appear to be rowing against our evidence as to the way in which we approached our risk analysis. In 93, the court appears to be acknowledging that addressing the problem gambler is not straightforward for a gambling service provider like SBG, because just as you have the risk of false negatives, you also have the risk of false positives, i.e. people you're concerned may be problem gamblers when they're actually gambling perfectly safely. And of course, if you interfere with the activities of someone who's on the platform who are in fact gambling safely, then that obviously interferes with their personal autonomy and indeed their Article 10 rights. So it's a question of balancing the competing risks in a world where you're always effectively having to guess whether or not the user is at risk and where the indicators of harm may ultimately amount to false signals. The next section of the judgment deals with the relationship between marketing and risk modelling. We see in paragraph 94 in the final sentence that all of SBG's witnesses were clear on the point that it's not in SBG's interest to market to customers who are at high risk of gambling harms, That's not something we want to do. At 95, the court notes that there's a single, what the court decides is a single systematic linkage between risk and marketing, which occurs at the point that the risk index is sufficiently high that it triggers suppression of all direct marketing for a period, which the court describes as a cliff edge that's not easily triggered. And I pause there to note that the position that we advanced before the court was that our approach to these issues was perfectly aligned with the safer gambling regime provided for under the Gambling Act, which regime, as we've seen, is specifically designed and intended to address the problem of problem gamblers. So, as I say, our position before the court was that we stayed the right side of the line in terms of compliance with safer gambling obligations, and as I've said, there's no finding that against us on that issue. In paragraph 97, the court repeats
just before you leave that.
Yes.
What about what the judge says in the second half of that paragraph?
So this is paragraph
But 95.
95.
Unless the suppression trigger is activated, the marketing team will market, including in cases where safer gambling intervention or suppression have been activated. So
Yes.
that is the position, is it?
I understand that is the position. Obviously, the challenge that we've, if we get to a point that we think the individual is effectively high risk, then everything is suppressed in effect. But if we can't get to that point, we're not at that point based on the evidence that's before us, then we have to proceed on the basis that the individual is making autonomous choices we have to respect. There's no kind of halfway house as far as my client is concerned, which, as I say, there's no finding by the judge that how he approached this matters was non-compliant with our safer gambling obligations.
Yes.
In the next section of the judgment, the court sets out what's described in the heading as an overview of lawful basis. This is just above paragraph 100. The court begins quite properly by recognising that the data protection regimes in place seek to strike a balance between, on the one hand, the protection of Article 8 privacy rights, and on the other, the freedom and flourishing of public life and modern business and trade. What the court seems to be saying in the final sentence of paragraph 100 is that the question of how you strike the balance in any particular case depends on the context. We take no objection to that finding. Paragraph 101, in the second sentence, the court notably does seem to recognise that the giving of consent is itself an assertion of individual autonomy. We agree, and we say it logically follows that controllers should not be required to second-guess consents which reasonably appear to them to be valid in nature precisely because it could risk cutting across the autonomous choices made by data subjects. The court goes on rightly in this paragraph to say that the quality of the consent matters, and it alludes in this context to the statutory requirements that must be met if the consent is to be valid. Paragraphs 102 and to 104 we have found particularly difficult to penetrate. The key points the court seems to be making here are, first, that consents may be mandatory in some contexts, as in the context of direct marketing, but not in all. Then it says that at the far end of the spectrum, reliance can be placed on legitimate interests. Not sure we understand that point. There are a variety of lawful bases. They're all permissible where they're engaged. Paragraph 105, the court seems to be making the point that whatever the basis relied on, there must be a good reason for the processing having regard to its impact on privacy rights. Well, if what the court means by that is there must be a lawful basis for the processing, we would agree. At paragraph 106, the court agrees with Mr. Hopkins that the key issue in the case is the consent issue, and so it's to that issue that the court turns in paragraph 107. At the end of that paragraph, the court asserts that the principal dispute was not about whether RTM made a choice to receive marketing, but whether that choice was sufficiently autonomous and informed. Then in the next section, the court launches into an analysis of the evidence on consent. Now, before we look at that section, I just want to note that the court does not at this point, or indeed at any other point in the judgment, take the opportunity to spell out, by reference to the pleadings or the written or oral arguments, precisely how RTM put this case on consent. Instead, the court appears to have proceeded on the basis that the issue of consent was effectively at large, such that she didn't need to concern herself overly much or indeed at all with the case which RTM had presented on the issue of consent.
Can you just give us the reference to how his case was pleaded on?
I'm going to come to that in ground one. I'll give you all the references in the pleadings, in the written arguments, and insofar as I can in the transcripts, in terms of how RTM put his case. The point that I'm making at this juncture is that the court does not analyse at any point in the judgment how RTM was putting his case on consent. As I said, it appears that the court take the view that the issue is simply at large, such that the court could decide it in whatever manner it chose. So then at 108, the court starts to analyse what it regards as the evidential background relevant to consent. The court begins at 109 by examining our consent mechanism for cookies. Those findings aren't an issue because we're not challenging the findings on cookie consent. So we can skip over in the judgment till we get to paragraph 117.
So just before we get there,
Yes.
at the end of 110,
Yes.
there seems now, in the judge's mind, to be a factual issue.
Mhm.
Did the claimant click the accept and close button? Was that both giving of and evidence of legally effective consent? So that seems to be the first issue.
Yes. So there was a question in respect, well, the claimant's position is he couldn't remember what he'd done. Albeit in respect of the first period, he said, in effect, it's not something I would have done.
Then he says he did. He accepted it. He would have clicked. Says paragraph 111.
Yes. Yes. So it depends which phase you're looking at because there were different regimes in place, just so that the court understands. In respect of the first period, our case was that the claimant actively indicated his consent by going into his marketing settings and and changing the settings to receive marketing. So if you like, whatever the nature of our consent mechanisms at that time, it was his proactive changing of his settings that meant he'd actively indicated.
And when did that happen?
On the 26th of July 2017.
That's where the judge said he did something, but she wasn't quite sure what.
I'll come back, that's our ground three, that I'll come back to at the very end. RTM disputed that he had gone into his marketing preferences on the 26th of July 2017, so he disputed that he had actively opted in.
But there are two occasions which are relevant. And there's this one,
Yes.
Paras 111, 110 and 111. The claimant ultimately accepts he did click the button.
Yes.
And then there's the second phase where the judge seems to find that he did something, but she wasn't sure what.
I think this paragraph is dealing with cookie consent, so the dispute was over direct marketing, and I'm, in my analysis, just not really looking at the sections of the judgment that deal with cookie consent for the reasons I've explained. Not at all. It is a complex judgment. So I was going to invite the court to look at paragraph 117. So here we find the court looking at the nature of consent mechanisms in the pre-GDPR period. We see from paragraph 117 in the next paragraph that in the first period we operated an opt-out consent mechanism, so people were opted in unless they opted out, albeit our case in respect to the first period was that didn't matter in respect of RTM. Because our case in respect of the first period was that he proactively changed his settings. Then if we turn to paragraph 125, where the court begins to look at the GDPR phase, the court notes at 125 that in common with many businesses, in April 2018, we instituted a consent refresh in anticipation of the coming into the force of the GDPR. And we see that the SBG's new consent mechanism required customers to accept a new set of terms and conditions, which they had to scroll through. They had to tick boxes confirming they'd read the terms and conditions and that they had accepted them. We see at paragraph 126 that the next step was a revised policy notice was presented to the user. So this is the court taking us through the journey, the consent mechanism journey in the context of the GDPR refresh. So the next step was that a revised privacy notice was presented to the user, which users were required to scroll through and tick a box confirming they'd read. And our records indicated that RTM had signed both boxes on the 6th of April 2018.
So there are 5 boxes to be ticked.
I think with the T's and C's.
Read.
Yeah.
Accepted.
Yes.
2 equivalent boxes for privacy policy and cookies.
Were there 3 boxes? How many
And then
boxes?
the last one for direct marketing. So that's 5 boxes ticked.
Yes, on three stages.
So there were 3 stages. How many boxes?
Yes.
5 in all. I think,
5 in all.
looking at these paragraphs.
I'm not going to second guess what Mr. Hopkins is saying about that. RTM's evidence in respect of the refresh process, because our case was something that we mandated all users to go through, was that he couldn't remember what had happened, but in any event, he hadn't read the policy. If anything, he would have just ticked the boxes to make the material go away. Then at 127, the final step concerned the choice about direct marketing. The court's description of what was presented to RTM in paragraph 127 is broadly accurate, but I'm keen that you look at the relevant screenshot, which you'll find in the supplemental bundle. It's the document I handed up this morning. So it's page 163A.
This is before the judge.
This was before the judge.
I'd have to have a
This one. The box.
magnifying glass to
Yes,
read some
I'm
of it.
sorry. I hadn't actually looked at the printout myself until just now. The box.
Maybe easier on the if we're given this electronically.
I can just summarise what it says. The box in the middle at the bottom, the page that's presented to the user or that was presented to RTM is you're in control of how we contact you. And then in bold, you're currently set to receive marketing from us. We'll email you to advise you of your current preferences. And then the choice that's offered is either continue with my current preferences or change my preferences. So RTM was told in terms through this screen that he was at that point opted in. So the question for him was whether he wanted to remain opted in or whether he wanted to change his settings. We can skip over the next bit of the judgment, which concerns the cookie mechanism, and then we pick it up again at 133. 133 to 34, the court sets out the key provisions of our post-GDPR privacy notice. Then at 135, we come to the section headed the standards for legally operative consent. 135 to 139 sets out the core provisions in recital 43. Then over the course of paragraphs 140 to 146, the court effectively notes a number of the key conclusions in Planet 49 on Romania, Leave EU and Meta platforms. As we see it, and as I was submitting earlier, the court has not identified anything in these judgments which would even remotely support a conclusion that the test for consent was subjective. Nonetheless, it goes on to say in paragraph 147 that the legislation the authorities require some unpacking, before saying in effect that the qualifications in Article 411 can be traced back to the concept of personal autonomy embedded in Article 8 of the Convention. The court then says there are 3 distinct strands perceptible.
Yes, I mean, I asked you earlier where you thought this had come from. No, the 3 strands,
Yes.
but if one looks at it, it looks like a sort of an article, and the question of personal autonomy obviously is very important in the context of Article 8. So it looks like this may be where this derives from.
Yes. So I think the point I was addressing is whether it emerges from the jurisprudence.
I understand that,
And
but
so it's absolutely right. We can see that the court is preoccupied with this notion of personal autonomy, which he traces back to Article 8.
Yeah.
Article 8, of course, being the original underpinning of the data protection legislation. There's no controversy over that. What she then does is to develop this 3-strand test, saying there are 3 distinct strands perceptible in this rather complex idea of personal autonomy. Now, as for those 3 strands, with all due respect to the judge, we say their essence is really rather difficult to capture. Save that critically, it is very clear that subjective considerations relating to the data subject's state of mind loom large in the analysis. We've seen that not least in paragraph 148, where the first element is said in terms to be the subjective element, this individual's state of mind, what they actually thought about, understood and desired. Now we say that already and immediately the court's gone wrong, because for the reasons I've outlined, this type of subjectivity is just irrelevant to the analysis. And of course the court doesn't refer to Cooper, so this judgment is per incuriam, Lord Justice Sale's judgment in Cooper. The court then goes on in paragraph 148 to say that while the subjective element is a requirement, it is not the only requirement, and it falls to be considered alongside the second element, which the court refers to as the autonomous choice about consent. Now here, the court seems to be venturing the notion that the second element is less about the individual state of mind and more about the external circumstances of their choices. That seems to suggest there's some sort of duality to the issue of consent, being concerned at one and the same time with being at one and the same time a subjective inner mind issue and an issue of externalities. The same is true of the first half of 149. And then the second half of 149, we start to get a sense of what the court's trying to get at here. What it seems to be saying is that you can have a data subject who's of sound mind, who in the exercise of their personal autonomy chooses not to read a privacy policy. The court seems to be saying that in those circumstances, you don't have a personal autonomy problem. All of the choices made by the data subject have been genuinely subjectively free, such that there is consent, notwithstanding that they've not absorbed the contents of the privacy policy. Well, we say that doesn't really get us beyond a focus on the subjective condition of the data subject and whether they effectively experience their choices as being genuinely free. Then we move on to paragraph 150. Again, we genuinely struggle to know how to interpret this paragraph, but ultimately it seems to cash out in a conclusion. But what matters ultimately is whether the data subject's choices were subjectively free. And whilst in most cases there won't be an issue with this, particularly if the controller's consent mechanisms are sufficiently robust, there will be cases where no matter how good, how robust the controller's consent mechanisms, there was in fact no subjective freedom. For example, because the data subject was mentally impaired, such that the consent will be invalid. If you then read 151, well, that paragraph read in isolation does rather create the impression that despite what's gone before, the court is actually focusing on the conventional objective issues concerning the quality of the consent mechanisms. But then at 152, we come to what the court describes as the third strand, what it labels the evidential element. And if you read to the end of that paragraph, you'll see that the court circles back to this notion that for some people, no matter how high quality the consent mechanisms, their consents won't be subjectively free, either because someone else ticked the box for them or because they lack the capacity to consent. So here the court seems to be concluding that no matter how high the quality of the consent mechanism, it cannot guarantee autonomy, and so cannot guarantee valid consent. And so the controller, it logically follows, cannot demonstrate valid consent. Then at 153, we see the court emphasising that in cases where consent is disputed, all three elements will be relevant, including the subjective element. And I just pause there to note that if the court was straightforwardly applying the standard, conventional, objective approach, all of this complex analysis could have been avoided. Thus, consistent with the case that RTM was actually presenting on the issue of consent, court could simply have focused on whether our consent mechanisms were up to scratch, including, for example, whether we adequately explained the processing we were undertaking in our privacy notices. Instead,
the judge refer to recital 32 in the discussion of ticking a box, because that seems to say that ticking a box is consent.
Well, I'm not sure that read in context, the recital can be read in that way, because that would render nugatory the requirements that it's freely chosen and freely given, informed and so on. So it clearly doesn't just rest on the fact that someone has ticked. What have they ticked? What do they understand about what have they been enabled to understand about what they're ticking? So I don't go so far as to say...
Well, that's the question, in your analysis, that's the question, an objective question based on the transparency and clarity, if I can use my own words here, of the information they're given.
Alternatively, if you have a consent mechanism that kind of litters the analysis so that the data subject, they're burying, what's really going on. So it could be transparency, it could be the littering problem, the burying problem that we know the legislation is opposed to. It could make the consent conditional in a way that means that the user doesn't actually have free choice. So there are all sorts of ways in which a consent mechanism may be objectively insufficient to enable the controller to demonstrate that the consents it has not only consents but are valid consents. But the court just isn't concerned with these issues. It's not what lies at the heart of its assessment.
Well, what the judge is talking about throughout these passages is the quality of the consenting behaviour, or in this passage in 152, consent being of the relevant quality. I think your submission is that it doesn't have to be of a relevant quality, it has to have some relevant qualities. And those are the ones set out in the words of the legislation. So it has to have the quality.
The question is, from whose perspective? The question is really from whose perspective does it have to have the requisite
It seems to me,
quality?
I'm reading this for the second time, now going through it for the third time, really, fourth, I think, given the PTA decision. There is a concentration on the quality of the consent, and I'm not quite sure I yet know what that means. But in my mind, that's distinct from it having some discernible qualities, not being of the quality. It's the superior quality of consent or the inferior quality of consent. To me, it seems it's either informed or it's not informed. It's either specific or it's not specific. This graduation is quite problematic.
Well, I agree that I completely agree that that having any form of graduation is problematic, because either way it's got to be informed and it's got to be freely given and it's got to be unambiguous.
Whatever the standard is, it's got to meet it.
Yes, the question really, it seems to us, boils down to from what perspective are you judging whether those absolute non-sliding scale requirements are met, and the court is approaching the issue on the basis it's all to be judged from the perspective, subjective perspective of the data subject, and we disagree with that.
Thank you.
So what we say that the court is actually trying to do through its three-strand analysis is really to introduce a subjective element and make it central to the analysis, particularly in cases where you may be dealing with data subjects who are not strictly of sound mind, if I can just use that term to really address what the court seems to be getting at in terms of RTM's mental impairment. So what we see is the court resolutely factoring into the analysis the subjective state of mind of the data subject, no matter that that's not consistent with the jurisprudence. It's impossible, we say, to square with the underlying regimes. Then at 155, we see the subjective element coming to the fore in the context of RTM's case on the facts. What the court does over the course of 155 to 167 is examine that first element, which is RTM's subjective state of mind. That culminates in a conclusion at 167 that the subjective element of consent was completely lacking in this case. He hadn't read the relevant policies and so had limited insight into the system, and his engagement with our marketing regime was itself bound up with his gambling disorder.
What about, before you go on, what about 157 and what the judge says in the last sentence there?
Well, I think that really just takes us back to the debate I was having with the court about, you know, in a sense it's not objectionable. The question is, did he give consent and to the required standard? But the question is, from whose perspective are you judging that issue?
And then judge starts with his subjective experience.
Yeah. 162, we see the court making clear that his subjective condition was such that he'd click through whatever was offered to him just to get rid of the messages on the screen and get on with gambling. So in effect, he chose not to inform himself, but court clearly thinks that's not a problem for RTM's case because that came about as a result of him being mentally impaired by reason of his gambling disorder. At 165, the court does find at the end of this paragraph that the suppression levels were set by SBG and at a level he couldn't realistically achieve given his modest means. We don't understand that finding because our approach to suppression isn't merely set by reference to the level of spend, as indeed we made clear in our evidence. But in any event, nothing turns on this point because, as I've already explained, the judge didn't find against this on the basis that judged objectively our approach to suppression was unduly constrained. Then at 168 to 185, there's a lengthy passage that seeks to examine what the court referred to as the second element. Now, we accept, as we must, that in the course of that passage, there is some discussion of our consent mechanism for direct marketing, both pre and post GDPR. We see that in 172 to 173, the court makes some comments about our mechanism in the pre-GDPR period. The court then goes on to examine the quality of our GDPR refresh mechanism. We see from the second half of paragraph 174 that our GDPR refresh mechanism was, as the court put it, considerably richer context for the consenting exercise than that which had preceded it. I have to say I'm not sure what the court's getting at in the final sentence of that paragraph, unless it's effectively saying, well, consent mechanisms are all well and good, but you still need to look at the subjective factor to get home on valid consent. Then in 175, the court makes clear that our GDPR regime requires the user to go through the process and to make active choices through their box ticking. See the final sentence in particular. 176, the court seems broadly content with our privacy notice. And then in 177, the court does make a number of further comments about our GDPR consent mechanism. This is a paragraph that's relied on particularly heavily by my learned friend. Given the concession we made in respect to the cookie consent, we invite you to focus in particular on the second half of that paragraph, where the court talks about our direct marketing consent mechanism. What the court says here is that, as she puts it, the mechanism has some evidential weaknesses. But then, the next paragraph, 178, is crucial, because the court doesn't go on to say, and I find that these evidential weaknesses were sufficient to render SBG's consent mechanisms objectively substandard, meaning no choice made through that mechanism, no matter the user, could be treated as demonstrably valid. Instead, the court reaches the opposite conclusion. What the court says in 178 is, in effect, for your average unimpaired user, subjectively unimpaired user, this consent mechanism was perfectly unobjectionable. Now, rather than take you through the remainder of this section, which is really important, paragraph by paragraph, I'm going to ask the court to read it up to 185, and then I'm going to make some submissions on it.
From where?
So from 178 through to 185.
We have actually all read this
Well, I'm
judgment
grateful.
on a number
I'm
of
very
occasions.
short on time, so I'll just move on to my submissions. What we say in short is that it's very clear that what the court is deciding here is that whilst for most users there'll be no difficulty with establishing valid consent, because those users will be of sound mind, and SBG's consent mechanisms are perfectly adequate for those users. There will be that irreducible, ineradicable minimum of cases where the consent mechanisms can't get SBG home on consent because the data subject was subjectively mentally impaired, such that no matter how good our consent mechanisms, those users could not have validly consented because their choices were not subjectively free due to their being mentally impaired. And then finally, RTM was himself a mentally impaired person, so that it follows that his choices were not subjectively free, and so his consent was not valid. We say there is simply no other way that you can read this critical passage. And crucially, our reading of this passage chimes completely with the summary conclusions that we looked at earlier. The picture is also substantially enforced by the remainder of the judgment, 186 to 187. Again, the core reasoning in these paragraphs is, when you're dealing with a cohort of users, which includes users who may be mentally impaired, however good your consent mechanism, they'll not get you home in terms of establishing valid consent. And whilst in the context of the gambling industry, you can manage those risks by adopting a safer gambling regime consistent with your Gambling Act obligations, ultimately you can never exclude the risk. There is, in other words, nothing you can do as a responsible service provider to achieve what the court describes as a complete insurance policy against unlawful processing. Here it is that we see the absolutely strict liability nature of the court's approach to consent. See paragraph 187. The remainder of the judgment is much the same vein. True it is that at 190 the court makes some observations about our approach to safer gambling compliance. However, those observations are expressly said to be made in passing. They plainly do not form part of the ratio of the judgment. And indeed, in the very next paragraph, 191, the court makes a point of saying that compliance with safer gambling obligations is in any event not the court's concern in the case. What we see the court doing is drawing from the safer gambling regime 2 points. The first point is that the gambling industry is an industry that attracts, The first point is that the gambling industry is an industry that attracts users who may be vulnerable and whose vulnerability may relate to the industry. Well, that was never in dispute. And then the second point the court draws at 192 is that in the circumstances, SBG was necessarily, demonstrably, as the court put it, carrying a substantial risk of marketing to problem gamblers. Again, not a point that we disputed. These points cash out in a conclusion in 193 that it follows that SBG was carrying a legal risk that it would end up marketing to some users unlawfully, because those users were subjectively incapable of consenting because of their impaired state of mind. See further the second sentence in that paragraph. It was a risk there was no subjective consent of any quality present. Indeed, we say 193 couldn't be clearer. The court is saying we lack valid consent in the case of users who are subjectively impaired because those users lack the subjective wherewithal to consent freely. The court is also saying that's a risk that we've chosen to take on, and so it's really just our tough luck if we end up with cases like RTMs. We say as a matter of law, that cannot be the right result for all the reasons that I've explained. Again, at 195, final sentence, consent cannot be guaranteed by systems. There is an ineradicable risk in relying on them. On 196, the carriage of that legal risk is a matter for the business. You see the final sentence of 196. In effect, whatever we do, however strong our consenting mechanisms and our safer gambling mechanism, we just can't rule out that we'll end up engaging in unlawful marketing because we can't effectively identify or exclude all vulnerable users. Same point in respect of 197 and again 199. And what we see here is that where the court is ultimately heading with its analysis, as we see from the third line, in the third line from the bottom of 199, what the court says is this: it is not necessary for online gambling providers to market to their customers in order to allow them to gamble. So what the court seems to be saying here is, actually, the legality problem isn't a problem. Because you can just, this is 199.
199, sorry, I missed that.
It's about the fourth line from the bottom. So what the court seems to be saying here is, actually, the legality problem that SBG is complaining about, or would be complaining about had the case been put to us, is not a problem because you can just stop marketing altogether to your millions of users, completely ignoring the utter disproportionality of that outcome from a commercial interest point of view and an Article 10 point of view, set against the background of that if the service provider is not doing enough to protect the interests of problem gamblers in the context of the safer gambling regime, it will in any event fall foul of its obligations under the Gambling Act. So then we come to the summary conclusions we've already looked at. It seems to us that those summary conclusions are really just the icing on the cake when it comes to our case on construction. The court was applying a subjective test, that there can be no real doubt, and it was a test that for all the reasons I've explained is wrong in law, and that I repeat the points I made at the outset of my submissions, that RTM seeks to defend this judgment, not by defending a subjective test for consent, because he knows that's legally untenable. Instead, what he seeks to persuade you is, look, the subjective considerations alighted on by the court are really just so much background music. And the main conclusions, the essential ratio of the judgment, centred on the objective adequacy of the consent mechanisms. But he just can't land that argument. If you read the judgment, it's very clear that the court did not decide the case against us based on a conclusion that our consent mechanisms were objectively inadequate. So having taken you through the judgment, I'm now keen, unless you have any questions on the judgment, to take you to our grounds, which I'm keen to canter through quite quickly because it's very important I don't squeeze Miss Emerson. Our ground one proceeds on the basis that the judge impermissibly decided this case on a basis which was never put to her by any party and which fell completely outside the four corners of consent, of the case on consent which RTM had advanced before her. We say this is wrong, and by itself it warrants the judgment being overturned. I want to deal with this ground, if I may, in this way. First, I'll address you on the question of the nature of the case which RTM presented to the court. Second, I'll address you on the question of the extent to which the court's analysis on consent aligned with the case that RTM presented. Third, I'll address you on the question of whether the court gave the parties a meaningful opportunity to consider and address the approach to consent outlined in her judgment. Fourth, I'm going to address you briefly on the law in this area because my time is very short, and if I need to, I'll deal with the detail in reply. And the fifth, I'll address you in respect of RTM's attempts to counter our case on ground one. So on the first issue, how RTM presented the case below, I can deal with this swiftly. The position straightforwardly is that RTM's case on consent was confined at all times to conventional, objective matters concerning whether RTM did in fact physically opt in the direct marketing, and second, with the general objective adequacy of our consent mechanisms. Now, I'm going to outline the various paragraphs in the pleadings and the arguments that was good my case on that submission, but I'm keen not to take up my time by taking you to the relevant paragraphs, in part because my learned friend has at no point in his written arguments sought to suggest that before the court he mounted a case on behalf of RTM that was based on the subjective condition of RTM when he opted in to the marketing. That formed no part of RTM's case, and my learned friend has never suggested otherwise. But for your notes, you can see the purely conventional complaints that RTM was advancing in the pleadings. So in the re-amended particulars of claim, you'll find the case on consent, paragraphs 41.5, has to be read together with paragraphs 26 and 27.1. The amended reply, paragraph 7. RTM's skeleton argument, which is in the supplemental bundle at tab 14. Relevant paragraphs 193 to 197. And then the written closing arguments, the relevant paragraphs are 72 to 77. The picture is exactly the same when it comes to RTM's oral submissions. Quite properly, my learned friend did not deviate from the orthodox conventional challenge that was being advanced in the pleadings and his written arguments. We see a neat summary of his position in his closing submissions in the supplemental bundle at page 556. Which I've just asked you to briefly look at. So it's the first box, top left-hand corner, page 614 in hearing bundle page 556. We have page 556. It's the top left-hand corner, and it's lines.
Which page are we on?
So it's page 556 of the supplemental bundle. And it's page 614 in the transcript, the internal transcript pagination. And it's lines 5 to 11. That's the case that was being advanced. It aligns with paragraph 5 of the claimant skeleton, RTM skeleton that I took you to earlier. The case was purely focused on conventional matters, had absolutely nothing to do with RTM's subjective state of mind or how that might have affected matters. And I should add that the fact that RTM approached this case on consent in that way with the benefit of expert high caliber legal advice is because it perfectly aligns with all the jurisprudence in this area and is entirely conventional. It would have been deeply unconventional, unorthodox and unprincipled to advance a case based on his subjective state of mind, which is no doubt why it is not something that he chose to do. Then turning to the next point, the question then becomes, to what extent was the court's judgment on consent aligned with the case that RTM had presented to it? Well, hopefully you already have the nub of my submissions on that point. The court decided the case on a subjective basis that formed absolutely no part of RTM's case at any point in the process. I'm going to come on to RTM's attempts to defend the judgment in respect of our ground 1 in due course, but it is important to note, as I said, that RTM does not proceed on the basis that our ground 1 fails because he did in fact put a subjective case in respect of the consent issue. He doesn't suggest that at all. I come on to what he says to defend the judgment in due course. For completeness, I note that in the course of our application for permission to appeal, we specifically complained of the fact that the judgment was decided on the basis of a case that wasn't put, and at that point alone warranted the judgment being overturned. That was dealt with in paragraphs 12 to 13 of her application for permission to appeal. The judge simply does not comment on those submissions in her refusal of permission. The next point that I'm keen to make is not only did the court unilaterally invent this new, wholly unorthodox case on consent, but it did not even attempt to put that case to the parties in any meaningful way at any point prior to promulgating the judgment. Now, I must be fair to the court. It is right to say that in the course of exchanges with Mr. Hopkins, in the course of closing argument, the court did at one point squarely ask him a question concerning the relevance of the data subject's state of mind. We see that in the supplemental bundle at 576. It's in the internal page 695, so the bottom left-hand of page 913. We see the judge asks, can the consent of a compulsive gambler to the marketing to him of gambling opportunities be freely given? And then Mr. Hopkins says, I think we're back into the same sort of territory that I think threatens to contaminate the argument between us at every turn. That was a reference to earlier, as I understand, to earlier discussions that Mr. Hopkins had with the court about the role of duty of care in the analysis. He says, an operator in our position cannot assume that there's going to be any inability to exercise free choice. That cannot be the starting assumption. However, so the court did put that question. What the court did not do, by any stretch of the imagination, is say to the parties, look, I'm inclined to decide this case, specifically by reference to RTM's subjective state of mind, and on the basis that that subjective state of mind was substantially impaired by reason of his gambling disorder, such that as a matter of law, his consents couldn't be treated as valid. And in that context, I'm minded to apply this three-stage test that I think emerges out of Article 8.
I think we have this point.
Well, I'm grateful. But it is a very serious point that I'm making. It's one thing for the court to invent an analysis. It's quite another to altogether fail to put it to the party. And prejudice is important in this context, of course. Had the court put that point, we would, of course, invited the court not to go down that route on the basis it fell outside the four corners of the pleaded case and was wrong as a matter of law. We never had that opportunity. And we say that there is very substantial prejudice for the following reasons. RTM never put his case on the basis he was subjectively impaired, such that his consents must be treated as invalid. That had the result that we did not cross-examine him on the question of his mental state at the time. Sorry, let me put the point properly. That had the result that we did not cross-examine him on the question of whether his mental state at the time was such that he wasn't in a position to make a subjectively free choice. This really comes back to the points we were discussing at the very outset of this case, which is there's potentially a spectrum of individuals who may, in terms of individuals who may be making bad decisions, not super rational decisions, but that doesn't mean that they're impaired such that you must treat them as not in effect making free choices. The simple point is we have no opportunity to cross-examine RTM on any of these issues because the subjective test wasn't put in issue. Relatedly, we had no opportunity to consider whether we wanted to avail ourselves of the defence provided for under Regulation 30. Now, as to that, the court criticises us in its reasons for refusing permission to appeal for not relying on the defence. But we would only realise that the defence was relevant if RTM's subjective mental state had been put in issue for the purposes of the case on consent. And that's something that simply didn't happen at any point during the trial process. So in effect, we were deprived of the ability to plead a defence which the court itself seems to think would, or at least may have been, a total answer to the claim.
I assume the judge circulated her judgment in draft before it was handed down. Were any of these points made at the time of receipt of the draft?
No. I mean, Mr. Hopkins says no, but that's not obviously the point of the exercise at that juncture. Suffice it to say, we had no clue that this was where the judge was going till the judgment landed on our desk. So the prejudice, therefore, could hardly have been more absolute. But the court appears not to have itself discerned these fatal difficulties with its judgment, and that it instead proceeds to criticise my client for not pleading a defence that we had no reason to suspect could be relevant is, we say, both remarkable and deeply concerning. In terms of the jurisprudence on invented case analysis, invented case theories, time's not with me. I don't have time to take you through the authorities in any detail. To the extent that I need to, I'm going to deal with the authorities in reply. I just want to make a few headline points, if I may. What we say in summary is that all the judgments in this area consistently demonstrate the following points or principles. First, the ultimate aim is, of course, to achieve fairness and justice in the particular case. Second, within our adversarial system of justice, that essentially means that the court should be deciding disputes on the basis of the cases which the parties present to it, hence the acute importance of the parties' pleadings. Fundamentally, the defendant should know what case it's being asked to answer, and it should only be expected to answer that case. Now, that's not to say that the court must, in all cases, rigidly confine parties to their respective pleaded cases.
I mean, I think you would say that that it provided it was clearly flagged up, so the parties had an opportunity to deal with it, then that might be an answer, depending on the circumstances.
I mean, every case has to be judged on its own merits, but we had a pleaded case against us.
Yes.
The RTM never.
Bruce, we do understand. You've made the point on a number of occasions now, so we do understand the case you're making here.
Yeah. There's obviously going to be a spectrum. It may be that an early interlocutory stage, the court, in query whether it's the function of the court to do this, it depends on the circumstances. The court may introduce a point that the parties haven't thought of, and the parties have to go away and think about it and maybe amend their pleadings. We're so far away from that in this case. So what I was going to say is, and this really deals with Vallet's point, that it's not, of course, the case that the court must in all cases rigidly confine parties to their respective pleaded cases. There may, for example, be cases where the defendant reveals new things at trial, to which the claimant must, in fairness, be allowed to respond. Alternatively, there may be cases where the parties put rival factual cases before the court, and the court decides that the truth lies somewhere in the middle of those rival cases, provided that that conclusion doesn't, for whatever reason, cause one or other party undue prejudice. That assessment by the court can properly be regarded as unobjectionable. However, where the court invents a case that effectively has got nothing to do with the pleaded case before it, and a fortiori where that case isn't even put to the parties, and it then decides the case based on that invented case theory, that will be straightforwardly unjust and unlawful, not least because it offends completely against the natural justice principle and because it makes a nonsense of our adversarial system of justice. We say all of this is obvious and frankly pretty trite. We say there's nothing in the authorities that would serve to support the conclusion that what the court did here was permissible. And notably, in the two cases that are before you upon which RTM relies, where the court upheld a judgment that included analysis that had been invented unilaterally by the court, which is Sabir and Phones for You, in both of those cases, the court decided not to overturn the judgment. But what we see from the Court of Appeal's judgment in both cases is it did so in circumstances where it was satisfied that, if you like, the invented finding didn't form the basis for the court's decision on the claim. We see the Court of Appeal making that point in Sabir at paragraphs 164 to 64 to 67, which is at page 211 of the authorities bundle. We see the Court of Appeal making the same point in Phones for You at 209 and at 214. And it was indeed because the invented finding didn't form the basis of the judgment in Phones for You that the court was content that there was no material prejudice that flowed from the court's inventiveness. The issue of prejudice being important to the court's analysis, as one sees from paragraph 194C of the judgment in Phones for You. Compare the instant case, where the court's inventiveness didn't play out at the margins of its decision, but instead lay at the very heart of its reasoning. It is the reason we lost on the consent issue. It resulted in us being fundamentally prejudiced. The injustice could hardly have been more absolute. And notably, in Al-Madani, the judgment wasn't upheld, even though the court had troubled itself to put the invented case to the parties, resulting in it being adopted by the claimant. That wasn't enough to rescue the judgment. Compare the instant case, where, as I say, the first we learned about the court's subjectivist approach was when the judgment landed on our desks. So it's really from a learned friend to say there's something in the authorities that supports the conclusion that a court can approach the fundamental issue at stake in the case in the way that this court did. Turning then to RTM's case in respect of our ground one, the case is, we say, limp at best. What he says in effect is this: my claim was to the effect there was no valid consent to direct marketing. SBG bore the burden of proof on whether there was valid consent. The court was entitled to look at all the evidence before it to decide whether that burden had been discharged. That evidence indicated that my RTM's judgment around marketing consent was impaired. It was perfectly proper for the court in those circumstances to decide whether SBG had discharged the burden that it bore on consent by reference to the evidence given. That line of argument very clearly goes nowhere. This was not an inquisitorial, but an adversarial process. We answered the case on consent which was put to us by RTM. To the extent that we bore any burden at all in this case, it inevitably fell to be discharged only by reference to the case on consent presented to us by RTM. It is simply a nonsense to suppose that merely because RTM gave some evidence in the course of the trial suggesting he may have a degree of mental impairment around his choices, that meant that the case on consent could be decided by reference to that evidence. That would turn all of the principles that we see emerging in the jurisprudence on its head, including Almadani, Ali and Dink, Sabir, and Phones for You. At paragraph 51 of his skeleton, RTM goes so far as to criticise my client for not cross-examining him on his evidence on these issues, but that's completely perverse. The reason we didn't cross-examine RTM on this element of his evidence is because it was strictly irrelevant in view of the case on consent he'd put before the court. At paragraph 52 of his skeleton, my learned friend asserts there's no prejudice because there's no element of surprise in the judgment, given the unchallenged unchallenged evidence that was given by RTM. Again, that is, with respect, an absurd submission. It cannot be the case that a party's case before the court can be taken to wax and wane simply by reference to the evidence they happen to give as a witness. Indeed, the judgment in Ali and Dink is completely opposed to that submission.
Was there a, in relation to the issue of damages, how was had the parties agreed, you forgive me, it maybe have been mentioned, had the parties agreed in advance that if the court found in a certain way on liability that damages would be dealt with separately?
Yes, I think that's right. And there is subject to what this court decides going to be a separate.
Not quite agreed in advance, but the judge suggested it at the outset of the hearing and everyone agreed that's sensible.
Thank you.
The evidence that is being discussed now was there, at least in part, in relation to damage.
Yes, so
and maybe other ways in which it was relevant.
Yes, I mean, obviously RTM's case was, I got all this direct marketing, that exacerbated my gambling decision, my gambling activities, is what is caused the loss. And, you know, we accept, we don't deny that in the course of the evidence, RTM gave some evidence to the effect that it was all a haze and nothing was very clear to him because he was so consumed by his gambling. Let's say that wasn't in the evidence. What we do say is it can't be that within our adversarial system of justice, particularly where a party is represented by the most eminent specialist counsel, that they can say something in evidence and suddenly that becomes the case. A fortiori, given that my learned friend didn't even adopt that evidence in his closing to submission, say, oh, well, now we have a very different kind of case in light of the evidence that's been given. So now it's all about his subjective state of mind.
Suppose you're right on this ground. What do we do? Do we have to have a retrial?
So I'm afraid, I mean, we'd love to avoid that outcome. I'm sure both sides would.
If
But
the trial's been unfair, there's not much choice, is there, except to
So-
have a retrial?
we've made submissions on disposal. Our submissions to the effect that this judgment has to be overturned and everybody has to go back to scratch, albeit that we do say, given the rather extreme circumstances of this case, that the case should not be remitted to the same judge. And we rely, for those purposes, as you'll see from our submissions, not just on the fact that the court has, with great respect, gone so wildly wrong in its approach to the law, but also it decided the case on the basis that wasn't put. Also the fact that it didn't trouble itself to even alert parties to the fact that that's what it was going to do. And also to the fact that if you look at the court's reasons in response to our application for permission to appeal, They embrace incredibly trenchant criticisms that my client, in effect, had the temerity to suggest that there's anything wrong with this judgment, relying on a defence that we didn't even know could be an issue. So that's what we say about disposal. In paragraphs 53 to 54 of his skeleton, my learned friend seeks to circle back to the argument that even if the court went wrong by taking into account subjective considerations, that doesn't matter because we still lost on the objective test because the court found that our consent mechanisms weren't up to scratch. Well, I've explained why he can't maintain that case. Paragraph 55 is skeleton. RTM seeks to portray our arguments on ground 1 as marginal arguments that don't materially add to our ground 2, where we beg to differ. Our complaint under ground 1 is very different to the complaint we make under ground 2. It is a fundamental complaint and by itself sufficient to warrant this judgment being overturned. So unless you have any questions for me, that's our case on ground 1. On ground 2, I've effectively already set out our case, and I'm not going to waste the court's time by repeating myself, but there's one point I do want to make on ground 2, and it concerns RTM's attempts to criticise my client for suggesting that this judgment has draconian consequences for our business model. What he says is, in truth, the court was just dealing with a sui generis case within a particular slice of historical time, and he casts this part of our case as what he describes as interim assertions that owe more to rhetoric than reality. That's what he says in paragraph 56 of his skeleton. We say those criticisms are manifestly unfair and unfounded. For the reasons I have explained, our concerns about the impact of this judgment are real and valid, and indeed they are supported by the judgment, because the court itself appears to have recognised that the only way we could deal with the legality problem thrown up by this judgment is just to stop marketing to all our users. So our case on these issues is not an unreal interim rhetorical device. It reflects the impossibility of the situation in which we find ourselves as a result of this judgment. And we say it cannot be the right result. It will make a nonsense of the legal framework. It's plainly not what the legislators intended. Unless you have any questions for me on ground 2, I was going to move on to ground 4. Thank you. Ground 4, I'm going to deal with this ground very shortly. It concerns paragraph 205 of the judgment, which is at page 119. This is where the court found that, as a matter of fact, we used cookies to enable the personalised direct marketing which we sent to RTM. And as you may have gathered, the marketing we sent to was in the form of emails. We say simply that was a conclusion that wasn't open to the court in all the circumstances. In paragraph 60 of our skeleton, we've summarised the evidential picture that was before the court concerning how we use the data derived from cookies. Just to summarise, the position in short is that there was no evidence before the court enabling it to conclude that cookie data fed into the personalisation of marketing emails, which was the form of marketing that was an issue in the case before the court. Cookies were used in the delivery of personalised forms of social media and digital display marketing to users on third-party websites and social media platforms. That was something we acknowledged in our evidence. But those forms of advertising are not, and were not in this claim, said to be direct marketing for PECA purposes. And they were not the focus of RTM's claim. Thus, cookie data may have been used in the delivery of digital display and social media marketing to users, but RTM's claim wasn't concerned with that form of marketing activity. It was instead firmly focused on the direct marketing emails he received from SBG. And the critical point is that the evidence before the court just doesn't support the conclusion that's embraced in paragraph 205.
Do you want to take us to any parts of the judgment apart from 205 in that context?
I don't think I need to, because I don't think the judge deals with it anywhere else.
Just 205.
If you want the evidence that was unchallenged, that we gave, that Mr. Wilkinson gave to the court on behalf of SBG as to that cookie data wasn't used to inform user profiling, you have that in paragraphs 14 to 18 of his statement, which are at page 493 of the supplemental bundle. So we say that the finding in paragraph 205 is not tenable because there was literally zero evidence to support it.
Well, the judge says at the beginning it follows. So she links what she says in 204 to 205.
Just one moment. Let me just...
I thought that there were 2 points that she was making there. That SBG's use of cookies for the purpose of personalised direct marketing to the claimant was a fact she found. And because she found that RTM did not validly consent, it followed that that use was not lawful because there wasn't a valid consent.
Yes.
But I think inherent is a finding of fact that the use of cookies was for the purpose of direct marketing.
Yes, there's a finding of fact in 205A that we used cookie data from cookies, derived from cookies put on RTM's devices for the purposes of the personalised direct marketing we sent to the claimant.
And you say that hasn't featured so far anywhere in the judgment.
And there was no evidence to support it. And I think, to be fair to my learned friend, he doesn't suggest there was. So that's just a factual finding that's straightforwardly not tenable and must be overturned. What RTM says about this in his skeleton of paragraph 98 is that the relevant paragraph can't be read in isolation. It's not in context some freestanding finding of fact, but rather a shorthand phrase to be read with the extensive findings as to how cookies were used and described throughout the relevant period. I'm not quite sure what that means. If he wants to point to where in the judgment the court analyses the evidence on how we used cookie data, he's at liberty to do so. As I say, we gave evidence on the issue. It wasn't challenged. We don't know what the basis is, what the court thought it was relying on when it made that finding, but we say it's not tenable because there was no evidence to support it. So that's our ground 4, and then briefly our ground 5. Ground 5 concerns the court's conclusions also in paragraph 205 that our internal marketing related processing had no lawful basis because we couldn't get home on an argument that it met the legitimate interest tests. Well, the court itself acknowledged in 205 that its finding on this issue was parasitic on its consent findings. So if we win on ground 1 or on ground 2 or on both, then that element of the judgment must also fall because of its parasitic nature. The only further point I need to make on paragraph 205 is that if you look at the final sentence of that paragraph, you can see that the court's conclusion on this issue also appears to have been influenced by a concession which it thought that SBG had made at the hearing. And you'll see the nature of the concession the court thought we made. The court thought that we conceded that we had no legitimate interest in profiling for personalised marketing to problem gamblers without their consent. Note the total lack of reference to whether we knew they were a problem gambler. You can see what Mr. Hopkins actually said in the supplemental bundle, page 566. And it's the bottom right-hand page, lines 17 to 19.
Can you give me the page reference again?
It's 566 of the appeal bundle, internal page 657, lines 17 to 19. So critical bit of the submission is if one has grounds to know that's the case. And the qualifier concerning our state of knowledge is crucial. It's consistent with our case that consent has to be based on an objective that has to be assessed on an objective basis, not by reference to the subjective state of mind of the data subject. That important qualification is completely ignored by the court in its characterisation of the concession.
Was there a transcript available of the hearing for the judge?
Yeah, they were provided daily, I understand. What the court appears to be doing is proceeding on the basis we'd somehow fallen in with the approach which the court adopts in her judgment, which is that everything turns on whether the user is in fact a problem gambler and what the nature of their subjective condition is. But we didn't fall in with that case because it was never put to us. And you can see the qualified way Malone made the point in his submissions to the court. So for that reason too, the analysis in paragraph 205 can't withstand scrutiny. And then finally, might I just ask how late the court is thinking of
I
sitting?
think we have an agreed timetable which has you finishing your submissions by 3:30,
I'm grateful if the court's happy for me to proceed on that basis.
and then we hear from the intervener
So I will.
for an hour.
I will try and get through ground 3. It is very much the tail end of our appeal. As I've said, we wouldn't have appealed if we were just concerned with that finding. We say that the court is wrong, but it's not what motivated this appeal. But I want to now explain to you why we say that the court's finding on the relevant issue was wrong in law. So ground 3 concerns the case we put below, that RTM had opted into receiving direct marketing on the 26th of July 2017 by changing his marketing preferences so that he was opted into receiving direct marketing. So our case was, on the 26th of July 2017, RTM had gone into his account and changed his marketing settings so as to opt in to receiving marketing. Now, RTM challenged that case. His case was, I can't recollect, in effect, what happened, but that's not something I would have done in the circumstances. So it's a weak form of opposition to our case. He's not saying it didn't happen, I know I didn't go in on such a date. Now, we say that the starting point for our ground 3 is that it's not actually clear that the court resolved this factual dispute against us. But for now, I simply know that if the court resolved the factual dispute against us, then our ground 3 proceeds on the basis that the court's conclusion was wrong in law, reasons that I'll come on to. What I'd like to do is just take you, in the first instance, through the judgment on this opt-in issue. We pick the judgment back up at paragraph 123, which is page 95 of the core bundle. And obviously, everybody is reaching back into the fairly distant past. The claim was brought in 2023, it was heard in 2024, so we're already 7 years on from the events in question. And we have witnesses who weren't in place at the time, so are doing their best to assist the court as to what happened on the balance of probabilities. And the court, the SBG presented a spreadsheet that we have in the supplemental bundle, just if you quickly want to look at it, which we said showed that on the 26th of June 2017, the claimant had gone into his marketing settings and switched them to on. The relevant page, just for your notes, is page 158 of the supplemental bundle. So we presented that evidence to the court on the basis it showed he had changed his settings and opted in. There was some discussion, given that the witnesses were not there at the time, as to whether what was shown by the spreadsheet could be inaccurate for some reason. And what our witness effectively said is there are 2 options. 1, he went in, changed the settings, or 2, there was some sort of system malfunction. Now, what we see in paragraph 123 of the judgment is that of those 2, if you like, case theories, the latter scenario is improbable. So of the case theories we ventured, the only case theories that's left is that he changed his marketing settings. Then the court then poses a question. The question is whether RTM opting in is, as the court put it, the only or the more likely alternative. Now that question suggests that what the court is focused on is whether there's another reasonably viable explanation for what's happened on the balance of probabilities, other than that he went in and changed his settings. Now at 124, we see the court accepting that the change came about as a result of something which RTM did. That's important because RTM's evidence was that he wasn't gambling that day and so likely wouldn't have been on the platform. Well, the court accept that he did do something on that day on the platform. The court then says it has little evidence for what RTM's action might have comprised. Well, that rather ignores the spreadsheet, which we said showed he'd opted in. It then says it hesitates in the circumstances to accept that it must proceed on the basis that the change resulted from a proactive choice by RTM, on the basis that all other possibilities are eliminable. It says it's largely a matter of speculation what RTM did, and the court will discuss the implications of that below. Now, pausing there, we say that logically it could only be a matter of speculation as to what RTM did if there was more than one reasonably viable theory as to what he might have done. As to that, we say the only reasonably viable theory that was before the court was the one that we presented. The court comes back to the issue at 163, which is at page 108. The court finds in 163, obviously when RTM started to receive marketing in July 2017, he was immediately aware of the fact. And the court says in terms, I can and do infer that on balance, he was more likely than not to have done something himself to trigger that change. So then the question is, well, what could that have something been other than changing his marketing settings? The paragraph then continues to point to the lack of evidence of exactly what he did or how he did it. Well, there was the spreadsheet. And the court goes on to conclude that it cannot therefore make speculative assumptions about the circumstances and quality of any consents he gave at the time. Now that seems to be about whether the consent was valid rather than whether he opted in or not. The remainder of this paragraph notes that RTM couldn't recollect what he did and was just caught up with his preoccupation with gambling. The court, notably in the very next paragraph, accepts that at some level...
I thought that earlier there'd been, that his evidence was he hadn't been on the platform to gamble that day.
Yes, but the court finds he was on the platform and that he did something. So we've at least managed to get the court that far. So the question is, what is that thing? That's the question that the court's posing. What is that thing that he did? Well, we've given our case theory. The question is whether there was another case theory that effectively meant the position was speculative as to whether he did one thing or something else. Now, the next paragraph is important, 164, because in this paragraph, the court accepts that at some level, not only did RTM want to receive direct marketing, he perhaps even craved it. And the court goes on in this paragraph, to note evidence that he was begging for opportunities on the chats, desperate as he was to access more gambling. Now, pausing there, the court has at this point decided that RTM likely did something on the 26th of July which resulted in his being marketed to. It's also decided that he likely wanted marketing to the point of positively craving it. We know that RTM didn't object to the marketing once he started receiving it, and indeed he was highly responsive to it. We get that from paragraph 165 of the judgment. The court has not identified any viable alternative, still less any reasonably viable alternative case theories as to what else RTM might be doing beyond changing his marketing settings. And what we say simply is, set against that background are the balance of probabilities, just as a matter of basic common sense. What's the most likely explanation for what he did on the 26th of July 2017 when he's craving marketing? The answer, obviously, we say, is that he went in and changed his settings. That's the most likely explanation on the balance of probabilities, set against the background that nobody seems to have ventured any theory that something else could have happened. Now, it may be that you take the view that ultimately this is where the judge was probably heading in her analysis, but that ultimately she didn't straightforwardly decide it in our favour. But at the very least, we say that the judgment doesn't clearly resolve this issue, because after paragraph 164, the analysis on the dispute just falls away. There's nothing more. It's not mentioned anywhere in the summary conclusions, where, of course, the court is focusing on issues around the claimant's subjective ability to consent. So maybe the court thought it just didn't need to decide the dispute on the facts about whether he opted in or not, because even if he did, he didn't have the requisite freedom of choice such that his consents were valid. But in any event, we say there is no clear decision against us on the issue. And I should, for completeness, note that we made clear in our application for permission to appeal that we were construing the judgment as deciding the dispute in our favour. That's in paragraph 41 of our application for permission. The judge said nothing in response to that part of our application. So we say there's, in fact, no clear determination against us on this particular issue. But if you're, so if you're with us on that, then obviously ground 3 falls away. You don't need to decide it because there's no adverse finding to be challenged.
Is that right? The burden is on you
Yes.
to demonstrate consent.
Yes.
Is the judge's ultimate conclusion no more than you hadn't discharged the burden of proof?
Well,
There's no finding against you, but equally there's no finding in your favour. Isn't that what you need?
well, I would say that if the judge was going to, if the judge had concluded that we hadn't discharged the burden, she was required to say that, because otherwise the question's left up in the air.
That I understand. But though you've been saying, well, there's no finding against us, but is that the right question?
So, as I say, the possibilities are, the court decided in our favour. I suspect that's probably reaching a little bit. The court decided it in RTM's favour. Well, I say you need something more than merely what we've got, what we've looked at in the judgment. Or the judge didn't decide the issue because it felt there was another sort of overarching point that meant that we lost. And it may be that you conclude that's ultimately the way the court dealt with matters. What I would say is there is no finding that says burden lies on SBG, I've taken into account all the evidence and I'm satisfied that there was another explanation, or that in all the circumstances there may have been another explanation such that SBG hasn't discharged its burden. So you'll have to confront the construction question of whether there's a finding against us.
I was just thinking of the Sherlock Holmes fallacy of RTM, which says that once you've eliminated the improbable, or the impossible, whatever's left, however improbable is the truth.
Yes.
Possible, so well, that may be true for detectives, but it's not true for courts of law.
Well, when you're applying the civil standard of proof, which is on the balance of probabilities, it's not the beyond reasonable doubt or beyond all doubt. We say what the court has to do is step back and say what's the most likely scenario here. The most likely scenario is we had a user who was desperate to gamble, who desperately wanted to receive gambling, who was on the platform, who did something on the platform. Balance of probabilities.
I can see that.
You have another point here, don't you, about the standard of proof?
Yes, we do. And it really links into the same. If the court did decide the issue against us, we don't want to be unduly critical of the court if it didn't actually decide the issue. But if it did, then that's where our ground 3 comes into play. And we say there are 2 errors in the court's approach. One, we say that the court resolved the dispute in effect by applying a higher evidential standard than the ordinary civil standard of proof. We rely in particular on paragraph 123, where the court says it's not beyond ambiguity what the spreadsheet means. We say that is really reflecting the fact that the court is applying a higher standard than the burden of proof standard, but in a way you don't really need that express finding. What you need to do is look at this judgment and say, well, what else does the court think it could have been? If your court's going to decide against us and decide that we haven't discharged the burden.
The court said earlier, didn't it, that technical glitch could be ruled out.
Yes.
So you rule out technical problem, and the question is, what are you left with?
Yeah. Well, we say all was left with as a viable case theory was that he changed his settings.
As I understand your argument, you're picking on some words. This is not meant pejoratively. You were identifying some words in the judgment, like the word eliminable, in paragraph 1, 2, 4, as indicative of the judge holding you to a standard that's higher than the balance of probabilities. Exactly. Possibly on the basis that that's how you put the argument. When Mr. Hopkins put the argument, there are only 2 possibilities. And then this would be the logical leap that you're criticising. I can't be sure this one is the right one, and therefore I can't make that finding.
What we would say is that the court has to apply a real world approach, and that it's not just to say, well, because there's something that nobody can think of, and no case theory that's been, there's no case theory that's been put forward to me, but that there could be something, who knows, that means you lose. You haven't discharged the burden. That is applying, it's not even applying a beyond reasonable doubt standard, it's applying a beyond all doubt standard.
So let's not go there. That's the jury question. But,
But in any event, as I say, we don't really have to kind of make our whole case rest on that beyond ambiguity language, although we say it's symptomatic of the problem, which is the court has a single case theory in front of it. It's completely credible. It's supported inferentially by the fact that this was a user who desperately wanted to receive marketing, and there's no other explanation. And yet, if the court did decide against us, well, what's the basis for that?
One of the things that the judge did find, that the claimant did something, and the effect of that was to change the marketing preferences. Do you need any more?
Well, we say we don't, but we're trying to confront what the judge is, the way the judge has approached it, which is we're in a world where everything's possible, and so you lose. It's just not the way the civil standard of proof works. The court has to step back from the evidence and say, okay, this happened a really long time ago. The claimant is not saying it definitively didn't happen. He remembers what he was doing on that day and he was nowhere near the platform. The court found, even though RTM said he wasn't on the platform, that he was. And then the question is, and the court also found he did something that changed the outcome in terms of him receiving direct marketing. And we say, well, yeah, that's because you changed your settings because you desperately wanted marketing. So for the court to find against us on this issue, what we say is, oh, at the very least, it should land on, but there is something else that could have happened that's got nothing to do with changing the settings, that means that actually something went wrong in your systems, which the court's already said didn't happen, or is improbable. So why have we lost, if we lost?
At the time of that particular event, it's the screen grab that you showed us earlier, that was the right one. The first one was when you were opted out, you could choose to opt in.
So just to be clear, the screenshot that I showed you earlier, where it said you're currently opted in, is for the GDPR refresh. So we're looking now at the pre-GDPR period, and it's right to say that in the pre-GDPR period, our consent mechanism was opt out. So if you didn't want marketing, you had to actively opt out of it. But in a sense, and you might say, well, that's not an adequate approach because you need something active, so passive doesn't work. That all doesn't matter because our case in respect of the first period was he went in and proactively changed his marketing settings. So that was the dispute, is on balance of probabilities, is that what he did? So we say there are two problems with this part of the judgment. One, the court is applying an impossibly high evidential standard, and it's wrong in law for that reason. And the other way of looking at the issue is to say there's just no cogent basis for the court's conclusion. On what basis did it conclude that something else might have happened? So, we say for that reason, this part of our challenge also should succeed. And of course, my learned friend has done what you would expect him to do, which is put lots of judgments before the court about appellate courts not interfering with the evaluative assessments of the lower court. But the question is, what was there to evaluate here? It's not like, for example, the lifestyle equities case where you're looking at whether a particular privacy policy is targeted to a particular country, where you have to apply a multifactorial assessment and weigh all the different factors. For sure, in those sorts of cases, the appellate court's very slow to interfere with the assessments of the court, albeit it will do so, as we see from lifestyle equities. I think it's paragraph 49 of the judgment. It will do so if there's a fundamental illogic or gap in the reasoning of the court, even in that scenario. But here, what's there to evaluate? There's one case theory that's inherently plausible, that's supported by the circumstantial evidence in a very serious way, and there's no other case theory that anybody's landed on. What's there to evaluate? So for those reasons, we say also that our ground 3 should succeed. I'm very grateful, giving you an extra 5 minutes, but I don't know if the stenographer needs a quick break. Unless you have, of course, you have any questions for me.
Well, I'm just trying to get that reference again in the bundle. It's because all of this is redacted, it's quite hard to
Yes, so,
understand. I've got line 1 on page 159.
you in the main bundle
And
or?
then the supplementary bundle, I think you gave as a reference to the spreadsheet
Yes,
that is referred to in the judgment at paragraph 120.
yes,
In the column contact OK, which switches from no to yes on the 26th of July
yes.
2017.
And just
Let's
so,
try and track that down.
yes, so can I just, before we do that, just explain to the court that you'll see two headings at the top of 158, contact OK and market contact OK. And you'll see, for example, in the first line, it says yes for contact OK and no for market contact OK. I'm not sure it matters, but just so that you know, our evidence before the court was that the market contact UK column related to a research project in effect that was never activated, so doesn't have any bearing on the reliability of the yeses and the nos in the contact OK column. But if you want to find where the 26th of July is, you go to the top of 159 and you'll see there are actually two entries on 159. So you may say, well, why is that happening? Because surely he only went in once. But we know from the judgment that he changed his email address on that date. So it may be that or I think the logical inference is that there are two entries because there are two email addresses the system now has to contend with.
I will rise for 5 minutes to give the shorthand writer a quick break and then be back for
Court arises.
premises.
Can I steal a bit of your power? Because I'm literally
Yeah,
down
absolutely.
to. Yeah. All right. Tennis student. Warmer and warmer.
Yeah. That's like that.
Music festival, so can you split your tickets? Yes, I can try not to do that. It also means making like when the train gets delayed, it's Claimant really difficult. Right, I can't have this open. Have you got a privacy screen? Sorry. I don't think that we need to bind people for notes. Peter's laughing at me. No plan. Sorry. Oh, what is going on? Always. It's been a long day.
You sure?
Yeah, thank you. Here, I take this one.
Isn't it all?
It's just a bit.
Yes.
Oh, I see. I wouldn't worry.
My colleague left, so
It really is.
so Lucy is these. Okay.
Give something that has great writing to get in from the village, you think it was kind of.
They got them. That's why she got misidentified. This is Jenny. Because she went back.
Is the court ready?
Focus watching.
Shall I find you through your submissions?
You can pass us some grapes.
Court rise if able.
Yes, Miss Emerson.
My lady, my lords, the Commissioner is grateful for the opportunity to address this court in relation to ground 2, namely the test for legally valid consent under the data protection and e-privacy regimes. As the court will no doubt appreciate, the correct approach to consent is of some importance in relation to both those regimes. Consent, of course, provides a lawful basis for processing personal data under Article 6 of the GDPR and under the predecessor regime under the Data Protection Act 1998 provided a condition for processing. The correct approach to consent is therefore of importance because it will determine what a data controller is required to demonstrate in order to rely on consent as a lawful basis for processing personal data. Consent is also an important component under the e-privacy regime. Subject to certain exceptions, consent is required for the use of cookies and direct marketing conducted by email, and therefore the approach this court adopts to consent will determine what must be demonstrated before the use of cookies and electronic forms of direct marketing are lawful. And of course, the approach adopted by this court will have consequences which extend beyond the facts of this particular case. And it is with that broader context in mind that the Commissioner has approached his intervention in this appeal, an intervention that arises because of a concern that the judgment in the High Court has created uncertainty as to what is required of data controllers in order to rely on consent. And with great respect to the learned judge, she has taken a wrong turning in terms of how the law should properly approach consent. My lady, I'll start by summarising the Commissioner's position in this appeal. The Commissioner's overarching submission is that the assessment of whether a data subject has provided legally valid consent to processing activities falls to be considered on an objective basis. The Commissioner submits that on a proper construction of the applicable legislative schemes, what is required is an objective assessment of whether the data subject has provided consent to the standards set out in the legislative tests. So Article 4, subparagraph 11 of the GDPR, and previously Articles 2H and 7A of the Data Protection Directive, which of course covered the earlier part of the period which the court is considering in this case. The burden of proof is on the data controller to establish legally valid consent, and it requires the controller to prove, firstly, that the data subject has, through active steps, provided an indication of their wishes, signifying their agreement, and secondly, that that indication meets 4 objective criteria, namely that the indication was freely given, specific, informed, and unambiguous. And my lady, my lords, in advancing a case that consent falls to be assessed on an objective basis, it is important to underscore 2 points at the outset. The first is what is meant by an objective approach. The respondent's position is that he supports, and the judge adopted, an objective approach to consent, where such an approach entails a retrospective inquiry into the internal state of mind of the data subject at the time consent was given, regardless of whether the data controller knew or should have known about that state of mind. With respect, we say that that is not properly considered an objective approach. An objective approach on conventional analysis considers the validity of the data subject's consent based on external, verifiable matters, rather than the uncommunicated internal state of mind. The second point is that in adopting an objective approach to consent, the Commissioner does not contend that the factual context is simply to be ignored, or that the individual position of the data subject is to be disregarded. And specifically, we do not say that RTM's subjectively experienced gambling problems are legally irrelevant in the analysis. Rather, that is only the first stage of the analysis. But what matters, we say, when applying an objective approach, is the extent to which the data controller knew or should have known about those vulnerabilities at the time. And an objective analysis on our approach does not ignore context. So the Commissioner respectfully submits that the learned judge erred in law in her approach to consent. And in summary, we say firstly that the judge articulated a novel 3-strand approach to the concept of consent, which does not properly reflect the legislation, and nor is it supported by the authorities. Further, on a proper interpretation of the judgment, We submit that the judge's approach to consent ultimately collapses into a subjective analysis. The judge ultimately concluded that RTM did not consent to the standard required because of his subjectively experienced gambling problems. And that conclusion was, we say, determinative at each stage of the judge's analysis. The judge made no findings that those problems were known or should have been known to the appellant. And the Commissioner respectfully submits that approach is an erroneous one. The Court has the Commissioner's detailed written argument at tab 17 of the core bundle. And in my all submissions and the time available to me today, I propose to focus on 3 topics. The first is to address the test for consent in the legislation by reference to the statutory language, the purpose of the legislation, and the relevant case law, all of which we submit support an objective approach. Secondly, I will address how the test for consent applies in the specific context of online gambling. And then finally, I'll turn briefly to the judgment and identify where, in our respectful submission, the learned judge erred in her analysis. My lady, neither the second nor the third of those issues should be confused with the separate question as to how the law applies to the facts of RTM's case. As the Commissioner made clear in his written submissions, he adopts a neutral position on how properly applied the test for consent should be applied to the respondent in light of the appellant's consenting processes and the appellant's actual or constructive knowledge of his gambling problems. Our focus is to assist the Court with the law, not the evaluation of factual evidence. So, my lady, against the backdrop of those introductory remarks, I turn to my first topic, the legal test for consent. The overarching legal framework which regulates the processing of personal data, the use of cookies and direct marketing is set out in paragraphs 5 to 11 of the Commissioner's written submissions. I don't propose to take the Court through that, not least because those paragraphs are not in dispute, and Ms. Proops has already helpfully taken the Court through the legal framework in some detail in her submissions this morning. The Commissioner's submission, as I've already mentioned, is that the test for legally valid consent is objective, and we submit that that is supported by the statutory language, legislative purpose, and the case law. And so I'm going to deal with each of those 3 points. Starting with the statutory language, it may be helpful at this juncture to turn up the relevant statutory materials which are in the authorities bundle. Firstly, the Data Protection Directive, which is behind tab 6, and the GDPR, which is behind tab 8 of the bundle. We'll start with the DPD, which is on page 73. The first point that we make is that the language used by the EU legislators to define consent is consistent with an objective approach which focuses on the outward manifestation of the data subject's wishes. The definition of consent as it originally appeared in the Data Protection Directive is in Article 2H, page 73 of the first volume of the authorities, and it read as follows. The data subject's consent shall mean any freely given, specific and informed indication of his wishes by which the data subject signifies his agreement, personal data relating to him being processed. Substantively, the same approach was then adopted in the GDPR, which we've already looked at, but just for completeness, it's at page 86 of the authorities bundle, Article 4, subparagraph 11, where consent is defined as freely given, specific, informed, and unambiguous indication, I do underscore indication, of the data subject's wishes, by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data. And what the Commissioner submits as notable about that definition is that consent is not defined simply by reference to the data subject's wishes, but rather by reference to the data subject's indication of their wishes, where it is through that indication that the data subject, quote, signifies his agreement. The legislative language therefore defines consent by reference to the demonstrable evidence of the data subject's wishes in a form which a data controller can readily observe and ascertain. The second point is that the definition of consent requires active, not passive steps on the part of the data subject. The CJEU in Planet 49 confirmed at paragraphs 51 to 52 that the requirement for an indication under the Data Protection Directive clearly pointed to active rather than passive behaviour. And that's page 638 for your note of the authorities bundle. The point was then made expressly within the wording of the GDPR and the definition in Article 411, which requires that the indication be given by a statement, by a clear affirmative action, a point reiterated in recital 32 on page 81, which states that consent should be given by a clear affirmative action, and at the bottom of the page, silence, pre-tick boxes or inactivity should not therefore constitute consent. The requirement for active consent is, we submit, fatal to any suggestion that consent can be established on a purely subjective basis, namely by reference to the actual state of mind of the data subject that is not verifiable or demonstrable. The third point, which supports that analysis, is the requirement for the indication to be unambiguous, which we say further supports an objective test. Article 7A of the Data Protection Directive on page 74 required a data subject to unambiguously give their consent. Is that in Article 7A? That was interpreted by the CJEU in Planet 49 as requiring active behaviour on the part of the data subject with a view to giving his or her consent may fulfil that requirement. That's paragraph 54 of Planet 49, page 638 for your note. So we see from that additional factor and the need for an unambiguous indication further support in my submission for an objective analysis. Indeed, if the validity of the data subject's consent turned on their internal state of mind that is not known or reasonably discoverable to the data controller, it is hard to see how an indication of consent could ever be unambiguous. The fourth point that we derive from the statutory language is the requirement that the data controller has the burden of proof in establishing consent, because that provides important context for how the test for consent should be interpreted. There's no dispute that the burden of proof lies on the data controller. That point was made expressly in Article 7.1 of the GDPR, which Ms. Proops has already taken us to, page 99, but it was also confirmed to be the position under the predecessor legislation, under the DPD, in a case called Orange Romania at paragraph 42, which is at page 651 for your note, and we don't need to go to it. It is the controller that is tasked with proving that a data subject has validly consented, both by providing the relevant indication and establishing that the qualifying criteria, they must be provable by the data controller. If they are not, Article 7.1 effectively imposes an impossible burden, we would say.
Is this where you get the idea of knowledge and or constructive knowledge on the part of the data controller? Does it all come from the burden of proof? There's nothing so far in the statutory language which suggests that what the data controller knows or doesn't know, that they will do.
My Lord, in part it's the burden of proof, but it's also a recognition that one has to land on an approach. There must be a way to assess whether this relevant indication has been given and whether it meets the full qualifying criteria.
It's entirely objective to go back to the first part.
Yes.
Then what the data controller does or doesn't know is irrelevant.
My Lord, we submit that you're faced with two competing arguments here. There's an argument that consent should be assessed on a subjective basis, which is essentially the approach that the judge adopted in our submission, which looks at the internal state of mind of the data subject retrospectively.
No, I'm following your
and the alternative. Yes, so I'm sorry.
The alternative is an objective test. So you ask, was the data subject provided with adequate information objectively? Did the data subject do something to signify that they had read or accepted that information and had made the choice objectively? Now, why does the data controller's state of knowledge have anything to do with any of that? But you do seem to accept that if the data controller knew or ought to have known something about the data subject, that might have a bearing on an objective test.
Yes.
What I'm wondering is where that comes from, and if it is a function of the burden of proof resting on the data controller.
It is largely a function of burden of proof, my lord. And it may be that there is also something of a difference between 3 of the qualifying criteria. So the informed, specific and unambiguous criteria, which we submit would be assessed solely by reference to an objective construction of the consenting processes. You look at what information has been provided to the data subject, what is the terms of their consent in response, and that those 3 topics can be conclusively determined on the basis of the consenting mechanisms alone. But freely given may be different in that it's not simply a question of the consenting mechanism. There may be matters that are broader in terms of the relationship between the data subject and the data controller, which bear on the question of whether consent was freely given. So, for example, the potential dominant market role in the meta case, which is obviously not a consenting process issue per se. It's a slightly broader inquiry into the relationship between the data controller and the data subject. Or the bundling example, the bundling of consent, or the question of whether there was a clear imbalance of power. And in that context, we say there is specific wording that supports our position, because the recital specifically refers to the imbalance of power being clear. And what we say that means is that it must be apparent, or should be apparent to the controller, that the imbalance of power exists.
Just one question about that imbalance of power. There's a lot of, the word specific is used twice in that recital. We're in recital 32.
Yes. Let me just kind of take that. Recital 32, my lord, you looking at. 43 refers to is the recital which deals with the clear imbalance of power.
Let me just get the one that I've marked out, which I've got 2 now.
There's one at page 83, which is the original one, but I think we've now got another one.
Yes, right. So 43, we are told that consent should not provide a valid legal ground for processing in a specific case where there's a clear imbalance. And it is therefore, I'm missing out some words, and is therefore unlikely that consent was freely given in all the circumstances of that specific situation. So clearly that's not laying down a general rule that in all situations where there's an imbalance of power, clear or otherwise, we must deem consent not to have been.
No,
it tends to focus on a particular situation. So it's not the case that where one party is a public authority and the other is not, that you can't have consent because one's more powerful than the other. So it seems to be a narrow exception to a general rule. That's one I'm writing some comment on. And the other is that it seems to present a hypothetical objective situation that doesn't depend on whether in fact on the particular in particular facts of that case the subject was oppressed or somehow influenced by the imbalance of power. It's just looking at the situation as it presented itself publicly. Are those good or bad points? Or irrelevant?
They're good points, my lord. The first point you, my lord, made was that a clear imbalance of power doesn't per se vitiate consent. That's of course right, and it's recognised in the Commissioner's guidance. It's essentially a 2-stage approach of, is there on the face of it a clear imbalance of power? And are there in fact circumstances in which, notwithstanding that imbalance, it is possible to prove that the data subject has in fact freely given consent?
I mean, is there room here for a sort of fact-specific analysis? So, for example, if somebody wrote in and said, I've ticked the box, but I didn't mean to. Can you please ignore it or something like that? I mean,
I think the analysis in that case would be that consent had been given but then withdrawn.
Yes, quite. So the fact you've ticked a box wouldn't be enough.
No.
But coming back to my Lord's point about knew or ought to have known, how does that feed into the analysis?
Well, my lord, we submit that that's the proper application of an objective test, because it wouldn't be right, for example, for a data controller, for example, the online gambling company, the example we've got in this case, to benefit from manifest defects in its own safer gambling procedures. So, for example, imagine a non-compliant gambling operator who had highly deficient processes for identifying problem gamblers. We would say that is not enough for them to avail themselves of consent by saying, well, we didn't spot that this individual was a problem gambler, and rely on its highly defective processes. If it should have done so, it should have had knowledge that an individual was a problem gambler operating properly effective mechanisms as required under the regulatory scheme.
The notion of consent, I would have thought, correct me if this is wrong, must be the same whatever activities you are doing on the internet. So if an alcoholic orders a bottle of whiskey from an online provider, by clicking on buttons in this, is that consent vitiated if the supplier of the whiskey knew or ought to have known that the buyer was an alcoholic? Or somebody being a shopaholic, buying things they can't afford?
Well, my lord, I think the inquiry is always fact specific, and the question that we are required to ask by the legislative scheme is, has consent been freely given? So you then ask yourself the question, well, which of the relevant parts of that test are applicable here? It's not a bundling of consent with other terms and conditions. You then ask, well, is there a detriment that's being inflicted on the individual? In your example of the purchase of alcohol, no. So the next question is, well, look, is there an imbalance of power? And in the gambling particular context, we say that where you have an individual who is suffering from a specific disorder or gambling problems that make them particularly vulnerable to the receipt of direct marketing, which is attempting to encourage them to gamble further, then that is an example of a situation where there may be a clear imbalance of power. There's obviously a separate question as to whether an individual who is purchasing alcohol is in the same type of relationship where the processing that they're consenting to, i.e. the purchasing, is bound to particular vulnerabilities. And of course, you could potentially see a scenario where an individual who has a problem with alcohol and an addiction to alcohol and is purchasing further alcoholic products online, that there could be an argument that that gives rise to a potential imbalance of power. And the problem that we say arises with the judge's analysis is that on her approach, any of those customers would not be giving valid consent, even though the retailer would have no knowledge of those problems and there would be no constructive knowledge.
Is that in the situation where the retailer knows or ought to have known that the buyer is an alcoholic, can't resist drinking, is doing himself harm by drinking too much, and is susceptible to direct marketing. So you would say, I think, consent has not been freely given in those circumstances.
If the court were to conclude that there was an imbalance of power because of that alcohol dependency, then yes, I think on our actual constructive knowledge approach, those vulnerabilities may vitiate consent. But the difference between
you're looking principally at recital 43, are you? Imbalance of power.
The imbalance of power seems to be the most appropriate limb under which to consider the vulnerabilities issue that my lord's put into me.
Imbalance of power, or does the imbalance of power arise simply because of vulnerability?
Well, in the abstract, we would say no, my lord. I think what is particular about, for example, the gambling context is that there is an inherent link between the vulnerability, the gambling addiction, and the processing in question, which is the provision of direct marketing, encouraging people to engage in further gambling. And it is in that specific context that we say there is potentially a clear imbalance of power. The extent to which a clear imbalance of power might exist in other cases is obviously a sort of more difficult question, but also so is the constructive knowledge question potentially more difficult.
It's very elusive, this concept of imbalance of power.
It is.
This is the only place we've got any references, isn't it? It's just in the recital. There's nothing in the body of the GDPR about it. There's nothing in the authorities. And the only example is a specific one about a public authority versus someone or some individual who isn't a public authority. Yes. Some are.
Yes.
It's quite a big inferential jump from that one specific instance to a broad range of situations where there's an imbalance of power, which could be enormously wide, because imbalances of power exist all over in all sorts of situations, and we've got an undefined category.
You do, and
I can't say that I've got an answer to what they meant by this, but it doesn't obviously say wherever in society you find a data controller operating in a situation where they're more powerful than the person they're dealing with, which is almost every commercial situation you can think of. There's got to be a fact-specific examination. That itself seems to be problematic.
my lord, yes, and the guidance is limited. Of course, we have the reference to the public authority example in the GDPR text itself. The guidance produced by the EDPB and the Commissioner refer to the additional example of an employer, and whether that might be a situation in which there's an imbalance of power because of the degree of dependency and lack of realistic alternatives. And of course, we have the example in the Meta case, where the CJEU concluded that the dominant market position of Facebook, or Meta, was a potentially relevant factor in assessing whether consent was freely given. But I'd absolutely accept my lord's point that we don't have a huge amount of guidance from the authorities as to how this concept of freely given and the imbalance of power should operate. And to that extent, there is a degree of reasoning from first principles and having regard to the purpose of the legislation and also the language in landing upon an analysis that we would say is a proportionate interpretation of the scheme and is consistent with the language which the EU legislators have adopted. So, my lord, those are submissions on the statutory language. Turning now to the statutory context and purpose, we make 3 points in that context. The first is that a proportionate interpretation of the legislation supports an objective approach to consent. Ms. Proops has already invited you to read recital 4, which highlights that the GDPR sought to strike a balance between the protection of privacy rights, but also balancing other interests in accordance with the principle of proportionality. The Commissioner submits that the subjective approach adopted by the judge gives rise to disproportionate impacts on data controllers. The first point, and in this respect I adopt Ms. Proops' argument, is that the judge's approach is tantamount to a strict liability or no-fault regime, which we say is a disproportionate application of the test. The second point that we make is that if the judge's approach to consent is upheld, in practice this will impose a significant burden on data controllers to make potentially intrusive inquiries of data subjects, potentially undermining their privacy rights and resulting in inconsistency with the data minimisation.
But would those inquiries be actually lawful? And if you were asked somebody to provide you with data about their health or their I see where that would go.
Well, my lady, I mean, that is the Commissioner's concern, that you've essentially, as a result of the judge's approach, triggered data controllers to embark upon extensive inquiries to satisfy themselves that their customers are not suffering from any sort of impairment or health condition that would potentially vitiate the consent that they're relying on for their direct marketing or their use of cookies, or indeed their processing more widely. And we do note that the judge seemed to recognise that point at paragraph 151 of her judgment, where she said that businesses could not operate their data systems by inquiring into every individual's customer's mind. So she recognised the point. But with respect, her approach is that data controllers will, in practical terms, have to carry the legal risk that they are engaged in unlawful processing, because there will always be some data subjects that, unbeknownst to them, are suffering from vulnerabilities which prevent them from exercising a free choice.
I'm slightly troubled about the evaluation of proportionality there, because I don't know what the evidential the factual starting point is. And she said, as we discussed earlier, did the judge at one point, that there aren't many. It's a small number of problem gamblers. Now, it may be true, maybe not. I'm not sure that it was explored evidentially. But as you point out, we're not only concerned with the impact of this decision on this particular area of activity. And so I'm not sure that the material is there for a proportionality analysis.
Well, my lord, I think the points that we make, and I think they're echoed by the submissions made by Ms. Proofs, is that a proportionate construction of this scheme on any analysis should not result in a situation where data controllers are essentially being held liable for unlawful processing by reference to factors which they cannot reasonably discover, or which they have to undertake extensive factual inquiries to try to mitigate that legal risk. And the judge described that risk as an irreducible minimum risk, or a risk which is ultimately ineradicable. That's paragraphs 196 and 181 of her judgment. And so she seems to contemplate that no matter how intrusive and how extensive the inquiries of the data subjects, there is still a risk of legal liability. And we say that one doesn't need evidence to support the submission that that's a disproportionate interpretation of the scheme. That's just simply clear on its face. My lord, the second and related point is one relating to legal certainty and practical workability. I don't think we did turn to this recital, but recital 7 of the GDPR, which is on page 80 of the authorities bundle, tab 8, makes specific reference to the need for legal and practical certainty. That recital is dealing with the rapid technological developments.
Which recital was it?
Recital 7, my lord, page 80, which starts those developments and the provisions.
It talks about legal and practical certainty.
My lady, yes, legal and practical certainty. So this is one of the objectives of the scheme. Legal and practical certainty for natural persons, economic operators and public authorities should be enhanced. So that's one of the purposes of this provision. And we say that's entirely consistent with an objective approach which enables data controllers to know where they stand. By contrast, the test applied by the judge, where consent is vitiated by reference to the individual state of mind, which is not known or reasonably discoverable, would undermine legal certainty and would be unworkable in practice. The third point that it's important to make is that we say an objective approach is in fact consistent with protecting the privacy rights of data subjects. It is not a one-sided or reductive approach to consent, as the respondent suggests, but an objective test protects the position of the data subject through demanding a high standard of consent, such that even where subjective consent is present, it will not be valid unless the circumstances in which that consent was given enable the data subject to give free, informed, specific, and unambiguous consent. It is not enough for the data controller to simply assert that the individual subjectively consented. They must prove that they have done so by reference to demonstrable evidence, and that they did so consistently with the legislative criteria. And that approach, where an objective test is applied in context, is not a novel one under the data protection regime or the law more generally. It in fact reflects the approach that the courts adopt to the fairness criteria under the data protection regime. And Ms. Proofs gave you the reference to the decision of Mr. Justice Swift in Vince, paragraph 37, that's on page 460 of the bundle, where the court makes clear that the fairness requirement has to be assessed by reference to an objective test that has regard to both the data controller and the data subject's interests and the wider public interest. It's also a very well-established approach to contractual construction, where the court does not inquire into the actual state of mind of the contracting parties, but applies an objective test, having regard to the context. And we have an example of that in the authorities bundle in the case of Edmonds, which deals with the question whether the parties intended to enter into contractual relations. And the court says that the approach is objective. It is not about inquiring into the party's actual state of mind. That's page 175 of the authorities bundle for your notes. So my lady, my lords, we say on a purposive approach, considering questions of proportionality, practical and legal certainty, and the protection of data subjects, all of those points strongly support an objective approach, where what matters is the actions and conduct of the data subject, not the inquiry into the data subject's subjective state of mind. Turning to the case law, the Commissioner submits that both the domestic and European law support an objective approach to consent. In terms of domestic law, the Commissioner does place reliance on the decision of this court in Cooper, which Ms. Proops has already dealt with, so I won't take you to it. The key paragraph is paragraph 102, and we make 4 very brief points about Cooper. Firstly, we say that Lord Justice Sales, as he then was plainly correct to analyse consent within the data protection regime as an objective concept, which turns on the outward manifestation of consent by the data subject. And we say that Cooper is binding authority, which supports an objective approach to consent under the Data Protection Act, and by analogy, the GDPR. The objective approach identified by Lord Justice Sales is also plainly consistent with the legislative policy he identified, namely that in a properly functioning data protection regime, a controller needs to understand what its obligations are. And that ties in with the point that I've just made to you about the need for legal certainty and practical certainty in operating this regime. Thirdly, we say that the approach of Lord Justice Sales, which looked at the construction of the contract on an objective analysis where that contract contained the terms of consent, is entirely consistent with the Commissioner's approach, that the focus of the inquiry should be on the objective construction of the consenting processes and the terms in which consent has been obtained and recorded. And the final point is that, of course, Mr. Cooper's case was that he had understood consent was more narrowly framed than as it was recorded in his employment contract. He thought that it applied only to data he himself had provided his employer, and it did not cover consent in relation to information given by a third party. But there's absolutely no suggestion in the Court of Appeal's judgment that there should have been some inquiry into what Mr. Cooper's subjective understanding was of what he had consented to, or indeed that his subjective understanding of the employment contract had any relevance to the analysis at all. So we do say that Cooper provides strong support for our approach. We also submit that there's nothing in the case law of the CJEU which contradicts the approach outlined by Lord Justice Sales. And in fact, the objective approach adopted is entirely consistent with the judgment of the Grand Chamber in Planet 49, which was handed down some 9 months later. And it probably is worth having a look at that, because I don't think we've looked at it yet today. It should be in the second authorities bundle, behind the first tab 26, although it may be, my lady, my lords, have a break in your authorities bundle at a different point to mine. I hope it's in volume 2, tab 26.
Can you give a page reference for electronic
My lady,
page?
yes, 601 it starts.
Thank you. Yes.
Planet 49 is, of course, a pre-IP completion date case, and therefore does bind this court. It was a cookies case, and therefore was considering consent under the Data Protection Directive and the GDPR. And if I could pick up the judgment at paragraph 51 on page 638. The court sets out the definition of consent in Article 2H of the Data Protection Directive. And then at paragraph 52 makes the point that I've already drawn to your attention, which is that the requirement of an indication of the data subject's wishes clearly points to active rather than passive behaviour. And therefore the pre-ticked box does not imply active behaviour. So that reinforces the submission I've already made. Down to paragraph 54, the court refers to Article 7A and the requirement for unambiguous consent, and again makes the point that only active behaviour on the part of the data subject will fulfil that requirement. Again, that's the point I made earlier. And the court says this at paragraph 55. In that regard, it would appear impossible in practice to ascertain objectively whether a website user had actually given his or her consent to the processing of his or her personal data by not deselecting a pre-tick checkbox, nor in any event whether the consent had been informed. And so what we say about this is that we see the CJEU expressly using the language of an objective assessment in the search for whether there is valid consent, not only in terms of whether there is an unambiguous indication, but also whether the informed criteria is satisfied. And we submit that that bolsters and supports the approach adopted in Cooper. And so in terms of the authorities, we say they point in one direction and one direction alone, which is that the test for consent is objective, and that there's nothing in the authorities' bundles that will support a subjective approach to consent. The broader point, which we also advance in relation to the jurisprudence of the CJEU, is that in terms of the 4 qualifying criteria for consent, those are also to be assessed on an objective basis. And I entirely appreciate that this case is largely focused on the freely given requirement, but it is in my submission relevant to briefly consider the unambiguous, informed and specific criteria, because they do have to be read together. They all form part of the statutory test for consent. And one of the points that we make is that it would be surprising if the EU legislators had intended an objective approach to be applied to the existence of the indication, the unambiguous, informed and specific nature of the consent, but that a wholly different approach would be adopted to the freely given criteria, which would then embark upon the sort of subjective inquiry that the judge appears to have adopted. So, my lady, my lord, starting with unambiguous, it is not disputed that this is an objective criteria. See RTM's reply submissions at paragraph 10.5. And I've already made the submission that the requirement for an unambiguous indication of wishes supports an objective test because it demands that consent is obvious to the data controller. That's the simple point. The informed criteria is also objective. Again, that does not appear to be in dispute. See RTM skeleton at paragraph 61.2, where he characterises the informed criteria as one which considers what the user could objectively understand about the processing, and his reply submissions at paragraph 10, subparagraph 4, which proceed on the correct basis that there is no requirement to check whether the data subject actually read and understood the information. And my lord, if authority for such an objective approach was needed, we find that in the Orange Romania judgment that Miss Proops took you to, paragraph 40, page 651, where we can see that the thrust of the requirement is to make information available to the data subject. And the inquiry is about the sufficiency and quality of that information, not whether the data subject actually read it and understood it. The specific criteria is closely tied, we would say, to the requirement that consent be informed. It essentially requires that the data subject's indication of their wishes is specific to the processing in question, rather than more generic processing, which fundamentally is a question of construction. It's a question of looking at the form in which consent has been expressed, taken together with the information available to the data subject.
Would it follow on your analysis that if the data controller knew that the data subject had not read the information, that consent would not have been given?
My lord, we would say that the requirement is to make the information available. So if the data controller made available to the data subject information of a high quality that was accessible and granular, etc., then it simply doesn't matter whether the data subject read it and understood it or didn't, or what the controller knew about that.
I'm just trying to see where actual constructive knowledge fits in.
My lord, and I think...
Does it only fit into freely given?
I think it has more relevance there, which was the point I made at the beginning, which is that the actual constructive knowledge test has less scope for application in the first 3 criteria, the unambiguous, specific and informed, because we would say that those are answered by reference solely to the consenting processes and an objective construction analysis. But I think we do recognise that freely given is a potentially wider inquiry because it does look more broadly at the relationship between the data subject and the data controller. And we see that in the language of the legislation, because the legislation essentially contemplates 3 scenarios which might fall foul of the freely given test. The first of those is the clear imbalance of power scenario. That's recital 43. The second is where you have bundled consent, which is shorthand for where consent is made a requirement of a contract or a service, but in fact, it's not necessary for the performance of the contract. Or the third section is where there's no free choice or the imposition of some sort of detriment to the data subject. So those categories, if you like, make clear that there is a need for a slightly broader analysis than simply looking at the consenting process on its face. And it's in that context that we say the actual constructive knowledge test comes in. And
do you just remind me where the detriment point comes in from the legislation?
Yes, recital 42. And for your note, the bundling point is Article 7.4 in recital 43.
Yeah.
And those scenarios, the three scenarios that we've just looked at, all essentially focus, we say, on the relationship between the controller and the data subject and address matters which are capable of affecting freedom of choice.
So do you say that if there's something else, take the example that Ms. Proust gave of the controlling and coercive partner who's not a data controller but just someone who's in the situation and afflicting the free will of the data subject, that's not part of the test?
Well, I think, my lord, one would have to ask yourself the question whether there was genuine free choice in that situation. It is not within the parameters of the sort of relational characterisation.
It's not something that it would be easy for the data controller to find out.
Precisely, and that's why we say that our test of actual constructive knowledge is a proportionate and correct one, because it seems almost impossible to come up with a situation where you would have actual or constructive knowledge of that. And so the controller should not be liable in those situations for facts which are affecting the subject state of mind, the data subject, that are wholly outside their knowledge or wholly outside of their ability to discover. But we do say, my lord, that there's nothing in the legislative scheme which suggests that the freely given criteria should be assessed on a subjective basis, which is essentially the analysis that the judge embarks upon.
I mean, the external, you say what's in 43 are external criteria that the court can say yay or nay to.
Yes, and in terms of the imbalance of power point, we go back to recital 43 and the requirement for it to be clear, which conveys that the imbalance must be obvious or apparent to the controller, that the word clear must have a meaning, the court must attribute it with a meaning. And that there's just no support in the scheme for the suggestion that there should be some broad-ranging inquiry into the subjective state of mind of the data subject and whether consent was freely given, and that's not a proportionate construction of the scheme. And I think perhaps to illustrate the point by way of an example, imagine that your gambling operator chooses to supplement their consenting processes with boxes for the data controller to tick, to say, I am not suffering from any gambling addiction, I confirm I am not suffering from any gambling harms, and I confirm that I am exercising a free choice in relation to my direct marketing. So a controller is faced with all of those boxes being ticked. But on the judge's approach, even if all those boxes are ticked, it is still not enough to establish that consent is freely given if in fact the data subject is experiencing gambling harms and has just ticked the boxes to get on with more gambling, which was essentially the position in RTM's case and the judge's analysis of his behaviour. So we just say that illustrates that this just cannot be the intended or proportionate way that the legislation is intended to operate. So drawing together the Commissioner's submissions on construction, we say that the statutory language clearly supports an objective approach, which is also bolstered by the principles of proportionality and legal certainty in the regime, and that the case law such as there is available to this court in Cooper and Planet 49 and the other cases that we've referred to in our written submissions are entirely consistent with an objective approach. Now, standing back from that, it's unclear to what extent the respondent actually disagrees with any of that analysis. We note what he says in his skeleton argument at paragraph 73. He says, consent is not solely in the mind of the data subject and has to be objectively expressed in a way that controllers can reliably understand. And we agree with that. Rather, the primary point that seems to be made by Mr. Knight in defending the judgment is that the judge has adopted an objective approach. And so that's really a question of construction of the judgment, and we disagree with him about that. And that's ultimately a point that you're going to have to resolve. And I'll turn to that very shortly. So, my lord, those are my submissions on construction, which is obviously the most significant part of our intervention. I'll deal briefly with my two remaining topics. Firstly, how does this all apply in the gambling context? And secondly, the position in respect of the judgment. So in terms of the first of those, in the gambling context, we address that in detail in our written submissions at paragraphs 40 to 52. And I just make 3 points orally and to underscore these points. The first point is that the Commissioner acknowledges that in the context of online gambling, there can be real harms suffered by individuals with gambling disorders and gambling-related harms. That is a risk that is obviously recognised in the regulatory regime operated by the Gambling Commission. And there is a particular risk that if you send direct marketing to consumers of online gambling, that direct marketing will result in those individuals being incentivised to further gambling and potentially lead to harm. Of course, that's not a point that is in dispute and is obviously relevant context for the court when considering the question of the imbalance of power. The second point that we make is that where a gambling operator is processing personal data for direct marketing purposes, our submission is that the primary mechanism within the data protection regime, which is designed to address the impact of processing on vulnerable consumers, is the requirement that data processing is fair. And of course, that is entirely separate from the requirement to identify a lawful basis for processing. A data controller will also need to comply with the data protection principles, including a requirement that data is processed fairly. And it's our submission that it is fairness rather than consent that is the more natural lens through which to assess whether the ongoing processing of personal data for the purposes of direct marketing is going to cause unjustified detriment to the data subject or breach their reasonable expectations as to what the data controller is using their personal information for. Unfortunately, the judge didn't consider the question of fairness because essentially she didn't need to in light of her other conclusions. But we do say that there is a risk that the judge has sought to grapple with this question through the lens of consent, and in so doing has distorted what we say the proper legal application of that test is, when the more natural home for this analysis is the requirement of fairness. The third point I make is that when assessing whether consent is given by a consumer in an online gambling context, it does call for a fact-specific analysis. And we say, contrary to the approach adopted by the judge, the Commissioner does not consider that a gambling operator is in an analogous position to a public authority or to an employer where there is a presumption that consent is not freely given. We say that those relationships are ones where a presumption or dependency is obvious and warranted because of the subordination inherent in those relationships and the absence of realistic alternatives. For example, a citizen will not have a realistic alternative where their data is being processed by the DWP for the purposes of social security benefits, or they're receiving urgent healthcare treatment by the NHS. Nor necessarily will an employee have a realistic alternative to consenting where an employer introduces CCTV in their work premises, or, for example, introduced facial recognition as part of an access criteria to work premises. But by contrast, in the gambling arena, we know that the vast majority of consumers of online gambling services are not suffering from gambling harms. And there is no justification, we would say, for a presumption against freely given consent in the gambling context.
Only that, but they've got other providers they can go to.
My lord, yes. And what we need is a fact-specific inquiry. And applying our objective approach, the question is whether the gambling operator knew or should reasonably have known that a particular consumer is suffering from gambling-related harms. Now, if the answer to that question is yes, then the gambling operator is unlikely to be able to demonstrate consent. is freely given. That is because an individual suffering from gambling harms is unlikely to be able to exercise free choice into consenting to direct marketing that encourages and provides them with opportunities for further gambling. And in those circumstances, there is likely to be an imbalance of power. But if the answer to that question is no, and the controller has no actual or constructive knowledge that the consumer is suffering from gambling harms, then on an objective approach, they will be able to demonstrate that consent is freely given. So how we say this applies in practice is that where a gambling operator is on notice that a person is at risk of suffering gambling harms, then absent further inquiries that enable them to demonstrate a person is genuinely exercising free choice, it is unlikely they will be able to demonstrate that consent is freely given. The indication by the data subject is not in those circumstances sufficient because the data controller knows or should know facts which mean they cannot discharge their burden of proof in Article 7 to show that consent was freely given. And my lord, of course, that occurs not just at the point of giving consent, but could occur at any point thereafter where the controller acquires actual or constructive knowledge of risk of gambling harms. And we say that that approach is entirely consistent with the objective approach set out in the regime and strikes a correct and proportionate balance. Turning now to the final and third topic, we do very briefly simply say that the judge's approach illustrates fundamental errors of analysis, and we gratefully adopt the submissions made by Ms. Proops in relation to the judgment. We've set out in detail in writing our analysis of the judgment. I make simply 4 headline points about the judgment. The first point is that we say the 3-strand approach articulated by the judge does not reflect the legislative language, nor does it provide, nor is it supported by any of the authorities or any of the guidance. Whilst the respondent seeks to reconcile the judge's 3-strand analysis with the legislative language at paragraph 61 of his skeleton, we say that that's an impermissible attempt to reconstruct the judgment, which fails to reflect the substance of the approach adopted by the judge. The second point is that the judge's first strand, her subjective consent, which looks at what the data subject actually thought about, understood and desired, has no place within a regime which seeks to demonstrate consent through an objective lens, and that with respect, her analysis in suggesting that subjective consent could be sufficient is erroneous and undermines the high standard for consent demanded by an objective approach. The third point is that we say the judge's second strand is not on proper analysis, an objective test for consent, and the respondent is wrong to characterise it as such. Ms. Proops has already taken the court to the judge's substantive conclusions at paragraphs 202 to 204. I won't go back to them, but it's plain in my submission that the judge clearly determines this case by reference to RTM's subjectively experienced gambling problems, and that those subjective matters are determinative of both her first and second strand. And paragraph 203 in particular is a clear illustration of that point. The fourth point is that we say what is missing from the judgment are the factual findings which are necessary if the court was truly applying an objective approach. We don't see the court engage in any clear analysis as to whether at the time the appellants knew or ought to have known that RTM was suffering from gambling harms, and that factual analysis was required in order to properly apply the objective approach. So in summary, we say with great respect to the learned judge, we do submit that she has erred in law and that her approach constitutes a departure from the legislative regime and the objective test for consent demanded by that regime. Accordingly, we invite this court to clarify the approach irrespective of your conclusion on ground 1, and with what we respectfully submit is a necessary course correction. My lady, my lords, unless I can assist the court with anything further, these are our submissions.
Thank you very much. We'll sit again tomorrow at 10:30. Thank you very much.
Court rise and able.